Filmed while eating? Why this Bodycam case wasn't a GDPR breach. Imagine eating lunch on a bench and suddenly a security guard films you with a Bodycam. Was that lawful under GDPR? In September 2025, Bavaria's higher administrative court dismissed a case involving just that. A man claimed he was wrongfully filmed by a shopping center guard while eating a kebab outside. He said it was a public bench and the filming lacked consent or warning. But the court sided with the State Data Protection Authority, which had already closed the complaint. Why? Because the bench, despite looking public, was within private property, and the center had house rules in place. That gave the operator a legitimate interest under Article 6.1 FGDPR. The authority had also met its duty under Article 57 GDPR to investigate the complaint. Conflicting stories and deleted footage meant the facts couldn't be confirmed, and the case turned into one person's word against another's. Key lessons for DPOs? Don't assume public-looking spaces are legally public. If recording, clearly document your legal basis and when notice was given. Preserve evidence early. Missing footage weakens the case. Like and subscribe for more real-world GDPR decisions data protection officers can actually use.